Welcome back to Winning Isn't Easy. So the first question I get is, can a disability carrier or plan's failure to reference a specific plan provision on which the claim denial was based change that standard of review? Now, the ultimate question for a federal court in reviewing a disability insurance carrier or disability plan's decision to deny or terminate benefits is not necessarily whether the disability carrier or the plan was right. In other words, did they make the correct decision? But whether there was a reasonable basis for the decision. And I think that's absolutely crazy. All of that's impacted by something called the standard of review. So to get to that decision, the court has to first determine the legal standard or the appropriate standard of review that they will be using in deciding your claim. Now, there are two standards of review. The first is most preferable, and that's called de novo. Under the de novo standard of review, the judge can substitute their own judgment for that of the plan or the disability carrier, and they can substitute and come to a different decision. But the second and more common standard of review is something called arbitrary and capricious. I really wish that it was arbitrary and capricious, but the reality is that it is a get out of jail free card because it puts strict limits on what we have to prove to establish that this decision was incorrect and get the court to reverse the denial or termination. Now, the applicable standard of review can be found within the terms of the policy or the plan. And what we're looking for is a grant of discretionary authority to the plan administrator or to the disability carrier to determine your eligibility for benefits or to interpret the terms of the policy. The type of language that indicates the applicable standard of review is arbitrary and capricious is basically where they are reserving jurisdiction to themselves to make the decision, interpret the terms, etc. Now, the failure to comply with the Department of Labor's claim procedure regulations can result in the claim being reviewed under what's called the de novo standard of review, unless the policy or plan has established procedures that are in full conformity with the ERISA regulations, and they can show that their failure to follow the rules, comply with the claims procedure regulations, was both inadvertent and harmless to you. And that's a case that's out of the Second Circuit. It's Halo versus Yale Health Plan. The plan or disability carrier bears the burden of proving strict compliance with the ERISA regulations, and that's 29 CFR section 2560.503 1G 1II. Now, that requires notification of any adverse benefit determination in a manner that's calculated to be understood by you. So they've got to write you a letter and they say, look, this is the specific provision or plan on which our determination is based. In other words, I expect when I read a denial or termination letter, a reference to a specific policy or plan term on which this whole determination is predicated. Other sections of the ERISA regulations require that you are entitled to what's called a full and fair review of your claim and an adverse benefit determination. So they have to provide you with an opportunity to basically understand not only the terms that they're applying, but the fact that this determination was conducted by an appropriate fiduciary of the plan who's not an individual who made the adverse decision. So when we're dealing with an appeal, it's, okay, what's the policy term? Who's involved here? What's the basis of this denial? In other words, it's not a rubber stamp. The employee who's assigned to handle the appeal is not the same person, and they're not allowed to defer to that initial denial. So the court's going to look at the denial letter. They're going to look for the specific policy term that's being cited. They're going to look for a summary of the material that they reviewed, including that of your physicians and their peer review physicians, so that the judge, when looking at this, can determine whether or not they followed the rules or regulations and whether or not they're therefore entitled to a deferential standard of review, or there's a different applicable standard of review, the de novo standard of review. Now, the court can be looking at this again to determine whether or not the reasoning is not supported by evidence or whether it's erroneous as a matter of law. In other words, they haven't really relied on credible evidence and the law that they're applying isn't appropriate. So the court's review of this evidence under the arbitrary and capricious standard of review is really crucial to determining whether or not the applicable standard of review is de novo or arbitrary and capricious. Got it? Let's take a break.